connection on I for listing.
Listing for what?
Listing
Listing for what?
in connection review petition.
এটা সাইলেবাসন মোশন হলে ডিম নহলে তার যাবে না।
May I please, Your Lordship? And I beg to mention item number 23, my lord. We have required to file a video opposition, my lord, we have
23 you wait, these are special drive
My-
cases.
May it please your lordship, my lord, in item number 31, I am praying for 3 weeks time to file affidavit in reply. Recently file affidavit in opposition.
You please wait, these are listed for a special purpose. You have seen the heading.
May I, dear Lord?
Yes.
Lordship, I am praying for listing this matter for withdrawal from our withdrawal.
May I please, Your Lordship, I beg to mention for listing of WPC 2532 for admission, any date coming
No,
week.
you have to put it in the register.
Okay.
Yes.
Your Lordship, I beg to mention item number 5.
Hmm? Yes. What do you want?
Your Lordship, as the conducting council was away,
What do you want?
mention, Lordship.
You
adjourn.
have mentioned, fine, we'll take it up. Mention for what?
Lordship, adjournment.
For how long?
Yes.
Mention adjournment for how long?
Day
On
after
the
tomorrow.
request of learned counsel for the petitioner, this matter stands adjourned for 2 weeks. Yes.
Much obliged.
Oh, motion holo.
Readiness for motion, item 1.
Yes.
My lord, there is a PCCF-led committee that verifies the claims of fixed pay workers. Let the petitioner approach, my lord, his claims will be verified and my lord consider.
All right. You take that. Heard Mr.
A Islam.
A. Islam, learned counsel appearing for the writ petitioners. Also heard Mr. I. Botaku, learned standing counsel, Forest Department, Assam, appearing on behalf of respond numbers.
All the respondents, 1 to 4.
Appearing on behalf of the respondents. Full stop. The case of the writ petitioners, comma, in a nutshell, comma, is that they were all appointed as masteral workers, stroke casual workers under different forestry ranges. In the different forestry ranges coming under the jurisdiction of Divisional Forest Officer, bracket DFO, bracket close, Karimganj, full stop. Accordingly, comma, they have been working as masteral stroke casual workers since last 4 decades, full stop. When an exercise was carried out to identify and prepare a list of casual workers who were appointed prior to AFRBM period, the names of the petitioners were not included, although they were eligible to be considered for regularization. Full stop. Being aggrieved thereby, this writ petition list was prepared in 2003, 2023. Aggrieved thereby, the present writ petition has been filed, seeking a writ of mandamus. Full stop. On instructions obtained, next para, from the department, Mr. Botaku, learned standing counsel, Forest Department, submits that at present there is a standing committee headed by an officer
PCCF.
headed by the PCCF, who is examining all claims of masteral workers stroke casual workers for regularization of their services, and therefore the petitioners be directed to approach the said committee by submitting appropriate representation. Full stop. According to Mr. Borthakur, if such a representation is submitted, the matter will be looked into by the concerned committee and appropriate action taken in respect thereof. Full stop. The learned counsel for the petitioner has also agreed to such an order from this court. In view of the above, and as agreed to by learned counsel for both the sides, this writ petition stands disposed of by permitting the petitioners to submit a representation before the concerned committee, ventilating their grievances. If such a representation is submitted within 6 weeks from today, the same may be considered on merit and appropriate decision be taken therein within a further period of 3 months from the date of receipt of the representation. Full stop. With the above observation, the writ petition stands closed.
Obliged.
Item 2. Page 12, paragraph 15, madam.
Page 12, para 15.
Direction will have to payment the minimum scale, madam, the petition as well.
The heard Mr. M. Dattal, our counsel for the petition, peruse the statements made in the contempt petition alleging willful disobedience of the order dated 30/8/2024 passed in WPC number 1798/2021. The present contempt case has been filed. Issue notice returnable in 8 weeks. Petitioner takes steps for service of notice upon the respondents by registered post with AD within a week from today.
Obliged. 3.
My lord, the order it starts at page 15, my lord. The operative portion is at page 27. The period of compliance, my lord, ends on 7/8/2025. 2024, my lord. There were 2 review petitions also, my lord.
Review petitions,
They have been disposed of, my lord, without touching the purport of the order, my lord.
Acha, we take on hard Mr. M. Sharma, our counsel for the petitioner, pending statements made in the contempt petition alleging willful disobedience of the judgment and order dated 9/4/2024 passed by this court in WPC number 6723/2013
13, my lord.
and the connected writ petition being WPC number 4948 of 2020. The instant petition has been filed. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD within a week from today.
I'm grateful, my lord.
Item 4.
There are certain factual developments in the matter. What had happened, my lord? I have filed an additional affidavit, my lord. On 26/6/2025, running page 108, my lord, I had submitted an application praying for extension of time to file my written statement. And my lord, they respond on the very next day, page 109, and they say, my lord, second paragraph, page 109, my lord, you are hereby directed to appear before the inquiry officer on 2nd July at 3 p.m. They serve it to me at 4:30 p.m., less than 24 hours time they are giving me, my lord. So I submit another representation, which your lordship will find at page 111. I say, my lord, kindly give me 2 weeks time to identify and secure the assistance of a defense assistant and also to file my written statement. And page 113, my lord will find their response. They say, page 113, acknowledging your letter under reference, that is my letter dated 1/7, it is informed that you have been given ample time for preparation and accordingly you are hereby directed to appear before the inquiry officer on 9th July. My lord, I submit a representation on 9th July, page 116, my lord will find the operative portion. My lord, the second last paragraph, page 116, my lord. I say, my lord, page 116.
Yes.
second last, I say, Madam, kindly note that 2 weeks with effect from 2/7/2025 will elapse on 16/7. As such, I request you to kindly grant me time till so and so as to enable me to prepare my written statement. Now, I filed this additional affidavit, my lord, on 10/7 so that I can bring these documents on record. On 10/7 itself, my lord, what they do in the late evening, they give me a letter. So 10/7 itself, my lord, late evening, they give me this letter. And the operative portion of the letter, my lord, will find at the second page, second paragraph. They say, my lord, in compliance with the provisions of the Assam Services Discipline and Appeal Rules, and in light of the above, it is hereby decided that the departmental proceeding inquiry shall proceed ex parte against you. So that they have decided that they will move ex parte, my lord. Although they have acknowledged my letter seeking 2 weeks' time to prepare my written statement and identify my lord defense assistant to assist me, my lord. So this is the position. And my lord, on the last occasion, if your lordship recalls, your lordship had fixed the matter today for consideration of the legal issues. Now, my lord, my only submission before your lordship is a bare perusal of the statement of allegation in both the show cause notices would reveal, my lord, both the show cause notices, both the allegations are based upon the corresponding criminal cases. And therefore, my lord, if I file my written statement, I'll be disclosing my defense in the DP, which would be prejudicial to me in the corresponding criminal cases. Now, therefore, my lord, I just want to place one, I've searched, and I just want to place one judgment, which might be of some assistance, my lord. Honorable Apex Court, it has taken a very balanced approach. Paragraph 16, my lord. Paragraph 16, my lord, placitum A.
Yes.
It says, suffice it to say that while there is no legal bar to the holding of the disciplinary proceedings and the criminal trial simultaneously, stay of disciplinary proceedings may be an advisable course of action in cases where the criminal charge against the employee is grave, and continuance of the disciplinary proceeding is likely to prejudice their defense before the criminal court. Gravity of the charge is, however, not by itself enough to determine the question unless the charge involves complicated question of fact, law and fact. The court examining the question must also keep in mind that the criminal trials get prolonged indefinitely, especially where the number of accused arranged for trial is large, as is the case at hand, and so are the number of witnesses cited by the prosecution. The court therefore has to draw a balance between the need for a fair trial to the accused on the one hand and the competing demand for an expeditious conclusion of the ongoing discipline proceedings on the other. An early conclusion of the DP has itself been seen by this court to be in the interest of the employees. And the my lord, operative portion, my lord, next is paragraph 19. That is what, my lord, is the operative portion. Paragraph 19, it says, in circumstances and taking into consideration all aspects mentioned above, as also keeping in view the fact that all the three courts below had exercised their discretion in favor of staying the ongoing disciplinary proceedings, we do not consider it fit to vacate the said order straight away. Interest of justice would, in our opinion, be sufficiently served if we direct the court dealing with the criminal charge against the respondents to conclude the proceedings as expeditiously as possible. But in any case, within a period of 1 year from the date of this order, we hope and trust that the trial court will take effective steps to ensure that the witnesses are served, appear, and examined. The court may, for that purpose, adjourn the case for no more than a fortnight every time an adjournment necessary. We also expect the accused in the criminal case to cooperate with the trial for an early completion of the proceedings. We say so because the experience has shown that the trials often linger on for a long time on account of non-availability of the defense lawyers to cross-examine the witnesses or on account of adjournments sought by them on the flimsiest of the grounds. All that needs to be avoided. Now, this is the most important portion, my lord. Placitum F. In case, however, the trial is not completed within 1 year from the date of this order, despite the steps which the trial court has been directed to take, disciplinary proceedings initiated against the respondents shall be resumed and concluded by the inquiry officer concerned. The impugned orders shall in that case stand vacated upon the inquiry of the period of 1 year. So, my lord, Stengen has said, my lord, it cannot indefinitely cannot be stayed, but till 1 year, my lord, it can be, my lord. If the
What is that you want to be stayed?
The disciplinary proceedings which have been initiated against me, because, my lord, if your lordship produces the statement of allegation in both the show cause.
Let us see what is there.
My lord will kindly see, my lord, page number there are two show cause notices, my lord.
Hmm.
The first show cause notice, my lord, will find at page 50. It starts at page 50. And the relevant portion, my lord, will find at page 51. That is what the statement of allegation
Hmm.
lies. Page 51 at the bottom, my lord.
Hmm.
May I just read down, my lord?
Yes.
Statement of allegation, page 51. Shri Partho Hazarika, section officer, Excise Department, was caught red-handed accepting bribe money amounting to rupees 24,500 from the complainant Shri Minmoy Das
Hmm.
to process the license for IMFL on shop, and was therefore arrested on 16/10/2024 in connection with the ACB PS case number 77 of 2024 under section 7A of the PC Act. Shri Partho Hazarika Excise Department demanded bribe of rupees 1 lakh from the complainant to process the license IMFL on shop. Out of 1 lakh of the bribe amount, rupees 40,000 has already been realized by Shri Partho Hazarika. Further, he has threatened the complainant that without the payment of the remaining bribe amount, he would not process the complainant's application for license. Subsequently, on complaint received by Shri Minmoy Das, a trap team was constituted by DV and AC and caught Partho Hazarika red-handed accepting bribe amount of rupees, my lord, 24,500 from the complainant of the case.
Hmm.
And the bottom part, the last part, my lord, your lordship will see at the concluding part, page 52. Hence, a case was registered by ACB PS case number so and so, and a trap team was constituted. So, my lord, the allegation in the statement of
Are you admitting that you are caught red-handed?
no, I'm not.
Then you
admitting.
deny it.
I will deny.
That's the only thing you can say here, nothing else.
I will
What
deny.
prejudice will be caused to you?
My lord,
Their allegation is you are caught red-handed while accepting bribe.
Right.
You can only do two things. Either say that yes or say no.
No.
You are going to say no, either it's disciplinary proceeding or criminal trial.
Right.
Say no.
Well,
What prejudice will be caused
the
to you?
prejudice lies if I say no,
Yes.
and if they conclude the DP against me and with an adverse order, that adverse order is going to be prejudicial.
Not
to me.
at all. Not at all. That's where you are, I'm sorry to say, you're totally wrong. It has got nothing to do with your criminal case. The same charges, you may be acquitted by the criminal code and the disciplinary proceeding may find you guilty. That's permissible.
My lord, in the DP, if they
So,
come to
Mr. Borua, these are all to be looked into from the facts and circumstances point, right? The law is that if a prejudice is caused, then the court is to look into. Otherwise, it's not a matter of right. So, looking at the allegation, in some cases, the allegations could be different. But here, the allegation is you are caught red-handed taking bribe.
Right.
All you can say is no,
No.
I have not taken bribe.
Yes.
I was not caught red-handed.
Yes.
Right.
Right.
You are going to say that in criminal proceeding and disciplinary proceeding. Go and say that. We can give you 7 days time to file written statement. Nothing beyond that. On facts, a person, there is an allegation that he has been caught red-handed while accepting bribe. He will deny it. They are to prove it.
Really.
What prejudice will be caused to you?
Because your lordship is aware, even in that Mark Paul Anthony, my lord, the only exception is DPs are not stayed as a matter of course, my lord. Your lordship is absolutely correct on that point. But the only exception is when the charges in the criminal proceeding and the charges in the department proceeding are one and the same. That is when the exception comes.
Where is the charge in the criminal case?
That charges has not been framed.
Therefore, how do you know it will be one? Have they told you?
On the prima facie, on the my lord, statement of allegation itself shows. In fact, my
You
lord,
have a chance to file his written statement.
In fact, Lordship, if Lordship comes to page 82, this was the last opportunity granted to him in the month of June, Lordship, this year. Whereas so cause was issued in the last year itself, about 12 months back. If
No,
Lordship
we
comes in
understand
7 days,
that,
yes, Lordship.
but
Lordship.
you file it in 7 days, you
Lordship.
file your written statement, and after that the proceeding will continue.
Lordship.
That's the only order at the moment.
that
we
is the
file.
only order. And
Mhm.
only thing, my lord, without taking too much of time, this question of law is already under consideration before your lordship, which your lordship will, I mean, if I can just place one page, just one page, if your lordship sees page number, my lord, if your lordship kindly comes to, my lord, I'll just, page 91.
Yes,
Page 91, in fact, page 91, my lord.
yes.
Just on the point of prejudice, page 91, the last paragraph. I'll just draw your lordship's attention.
Yes.
The learned counsel of the petitioner submits that the entire proceedings are based out of the allegations made in the FIR lodged by OC in the Horolum police station. It is submitted that while there is no bar for simultaneous continuation of criminal proceeding and departmental proceeding, however, in cases where the departmental proceedings are based entirely on the same facts and circumstances as are involved in the criminal matter, It is a matter of necessity that the departmental proceedings should be stayed until criminal trial proceeding concludes. The learned counsel submits that as on that the matter is still under investigation and charge sheet has not been filed. He submits that if both the proceedings are allowed to continue, the petitioner will face a grave prejudice. Why? My lord, the answer is also there. In support of his contentions, the learned counsel relies on so-and-so judgment. Referring to the judgments, the learned counsel for the petitioner submits that this is an appropriate case to defer the DP until the disposal of the criminal matter, as the facts and circumstances involved in the criminal.
So what are you trying to show from this?
What I was trying to show was in the next line, my lord.
Hmm.
And in the event the department in the discipline proceeding arrives at the conclusion which is adverse to the petitioner, the same is likely to prejudice the petitioner as the matter is still.
But that is the submission of the
That's
counsel.
submission. And my lord will see
The submission is binding on the court.
No, not submission, but the consideration.
Hmm.
This was the submission by the council.
What is
And-
you are relying upon an order. So the ratio only is binding. Take me to the ratio.
Right.
Yes.
The ratio, your lordship will find page 94. 94, the last paragraph.
Yes.
The consideration of the learned court.
Hmm.
Page 94, the last paragraph.
Hmm.
Under such circumstances, as the investigation is still underway and no charge sheet has yet been filed, and also as it prima facie appears to the court that the materials relied upon in the disciplinary proceedings and the investigations carried on by the investigating authority relate to and arise out of the same incident, it is not possible to arrive at the conclusion at this stage that simultaneous proceedings are not going to be prejudicial to the writ petition. And therefore, on that count, the DP in that case was, my lord.
Yeah, but this view of the learned single judge does not appear to be in consonance with the Supreme Court judgment. So I will have to follow the Supreme Court judgment.
That is there. Perhaps the court, the honorable court, had kept in mind that Mark Paul Anthony and the other cases where they had said, perhaps, my lord, I'm just.
Well, that's all right. I do not wish to comment on this judgment, but this does not appear to be in consonance with the Supreme Court decision. There can't be a presumption of prejudice. Prejudice has to be established, and you are right. In a given case, if it can be shown that for this reason, I cannot disclose my defense because this is how I'll be prejudiced, then the courts will interfere. But you can't come and say that, see, there is a departmental proceeding, so there will be a criminal proceeding. Some charge sheet will come. It is likely to be same. So it is likely to cause prejudice, so stay. That's not the law. That cannot be done unless you differ with that. And in that case, you can address argument. There can't be a presumption. Speculative orders cannot be passed. It may be correct that possibility is there, but you have to show it. And the problem in your case is that you just need to, I cannot tell you what you should write, but you are just required to deny it. That's all. What prejudice will be caused if you deny the allegation?
Look, if I deny it won't, but if they arrive, tomorrow that.
Show me a judgment.
That I have.
Show me a decision.
Right.
That disciplinary proceeding, if the charge is proved, that means you will be convicted in criminal case. If there is a judgment, I will allow your writ petition today itself. Is there any such judgment? That's not the law.
I have searched during the summer.
You will not get it.
I did not.
You can search in the winter vacation also. You will not get it.
But Lordship, I can place one judgment in my favor, Lordship. This is not only a case of demanding and taking bribe, Lordship. It is also a case in which a rupees 47 lakhs in case was recovered from his house. And this is not disclosure of defense, Lordship. This one small paragraph, this is 2005 10 SCC 471. It's a small paragraph, Lordship. Kindly show it. This is not disclosure of defense.
You give him 7 days time to file his return statement.
Lordship.
We'll have it after 7 days.
I have no issue. He just needs to tell us the source, Lordship, where from he gathered that, accumulated that amount of money.
Yes, that's correct. That's what I've been saying. I didn't read this judgment earlier, but you're not going to disclose your defense. Question doesn't arise. If I do it, I'll be deciding hundreds of cases which are pending. Till this is the first time he has taken this plea. Don't disclose your defense. If that is causing prejudice, don't disclose it. Where is the question of you disclosing your defense in a criminal proceeding? In the disciplinary proceeding, where is the question? Unless you can specifically show that I have to say this, and if I say this is going to that. If you deny it, how is it going to prejudice you? In criminal trial, You can either deny or keep quiet. So, Mr. Borua, 7 days time, I'm not writing anything in the order. Mr. Nayak,
Lordship,
Huh?
not the filings.
heard Mr. A.K. Borwal and counsel for the petitioner. Apart from being aggrieved with the fact that a departmental proceeding initiated against the petitioner is allegedly based on the same incident and same set of facts with regard in respect to which a criminal proceeding has been pending against him. The writ petitioner is also aggrieved by the recent communication dated 10/7/2025 issued by the disciplinary authority directing that the pending departmental proceeding shall continue ex parte against the petitioner on account of his failure to file written statement. The petitioner has approached this court inter alia contending that although an application was submitted before the authorities on
My lord, I had submitted that application, my lord, on 17/6/2025.
on 17/6/2025, seeking time till 16/7/2020. 17/6, is it? Where is it?
It is, my lord,
9/7. Yes.
9/7, I'm sorry, 9/7,
On 9/7/2025,
115.
seeking time till 16/7/2025 to submit his written statement. The prayer of the petitioner has been rejected by the order dated 10/7/2025 without any valid reason. First up. Responding to the above, Mr. P. Nayak, Nailat Additional AG, Assam, appearing for the respondents, has submitted in his usual fairness that if the court directs, the petitioner can be granted another 7 days time with effect from today for filing his written statement. First up. Although there are larger issues involved in this writ petition, yet this court is of the opinion that for the present, ends of justice will be met if the petitioner is permitted to submit his written statement. As such, 7 days time with effect from today is granted to the petitioner to submit his written statement of defense in the departmental proceeding if the same is submitted within 7 days from today, that is on or before 21st of July 2025, the same shall be taken on record. The matter shall proceed thereafter, subject to further orders that may be passed in the present proceeding. The order dated 10/7/2025, issued under memo number 670917/12 by the additional Secretary to the Government of Assam, Transport Department and Enquiry Officer, stands modified to the above extent. Let this writ petition be listed again on 23rd of July 2025 for motion. Then we'll consider what is to be done.
If Lordship has granted him 7 days time, Lordship, this may be closed, Lordship. It will proceed, Lordship. The DP, your Lordship is not allowing his prayer.
No. He has raised a query which prima facie is not made out a case.
Lordship.
But final verdict cannot be given.
Larger question remains.
Larger question is there. The law is that it will depend on the facts of the case. I have not come across a single judgment or a single matter where any of the petitioner has shown any prejudice. These are all presumed prejudice.
No, my submission would be, Lordship, he's saying that I am going to be prejudiced.
We'll pass an order on 23rd. We'll fix it
Right.
for motion.
Deeply.
Good. Let us see what happens once he submits a written statement. Then we'll
Lordship.
pass an order.
In 6.
This is the second litigation, my lord. In 2014, he was, my lord, discharged on medical ground.
Hmm.
The discharge order was challenged, my lord. The 2014 writ petition was pending till 2024. In June 2024, my lord, the prayer for reinstatement, my lord, was rejected by this court at Annex 8, page 35. My lord, the fact remains that he was discharged on medical ground. So the issue, my lord, thereafter that was raised by the petitioner was that whether he would be entitled to.
He was
extraordinary
discharged
pension.
12, 13 years back.
My lord.
Then,
My lord, the writ petition was pending. Therefore, I could not raise the claim for pension. My prayer in the first writ petition was to reinstate my lord into service. That was rejected, my lord. I have accepted it now. The question is, my lord, now that whether discharge on medical ground would entitle him to, my lord, disability.
I heard Mr. B. Patel, learned counsel for the writ petitioner, perused the averments made in the writ petition. The petitioner herein, who was working as a clerk under the, he was working as a clerk under
Assam Rifles.
under the Assam Rifles, was discharged from service on 30/8/2012 on medical grounds. Full stop. The present writ petition has been filed seeking a writ of mandamus directing the respondents to extend pensionary benefits to the petitioner. Full stop. There is no CGC here. No CGC is appearing. Any central government council? Have you served copy on anyone?
My lord, we have served.
Mr. R.K.D. Chaudhary, learned DSGY, has appeared for the respondents and has prayed for time to obtain instruction. Issue notice returnable in 8 weeks. Since the respondents are represented, no formal notice, extra copies be served. The issue of maintainability of the writ petition on the ground of delay in approaching the court is kept open and shall be gone into at the stage of admission. Yes.
Oblige, my
This matter pertains to appointment on compassionate ground. The
Hmm.
petitioner has applied for.
All compassion has dried up now. What are you expecting?
Lordship,
There is no compassion left anymore.
whatever Lordship, her candidature was considered Lordship by the SLC for the first time in the year 2023.
Hmm.
Subject to availability of the post. Lordship. Thereafter, again, it was placed before the SLC. Lordship.
We'll only issue notice and
Only-
deal with the
Lordship, similarly-
admission stage. Will close. Heard Mr.
Similarly
Bihar.
situated person is approached this honorable court and
Oh.
Lordship has passed an order.
Hmm.
Lordship, kindly come to the page 28. Lordship.
Page.
Page 28. Lordship.
Hmm. Yes.
Same ground, Lordship, that was also rejected. Citing the OM, Lordship. Lordship has passed this order, Lordship.
Yeah, but you have to study a little bit. First, you have to study the judgment,
Yes, Lordship.
and then you have to see what the judgment says. Anybody who has approached the court before the disposal of those cases will only be entitled to the benefit of the judgment.
Lordship,
You have come long after the judgment was passed.
Lordship, in the said judgment, Lordship, it was said that
Show me the judgment. Where is the judgment?
Lordship, page
Page.
28 onwards. Lordship.
Page 28 onwards. Yes.
Page 33,
Hmm.
even paragraph is paragraph 7 and 10. Lordship.
No, you are seeking the benefit of judgment dated 3/4/2025, passed by the coordinate bench,
I'm
right?
seeking my petition may be disposed of on the light of the petitioner.
So therefore, you have to show that, like the other petitioner, you also come within the ambit of 3/4/2025.
Lordship,
All right, I heard Mr. B. Halder, counsel for the petitioner, perused the averments made in the writ petition. The matter pertains to prayer for appointment on compassionate ground. Ms. M. Bhattacharjee, learned additional GA Assam, submits that the writ petition is not maintainable. However, she seeks 4 weeks time to complete her instructions. NOM 6 weeks. Since Ms. Bhattacharjee has appeared and accepted notice for all the respondents, no formal notice, extra copies, let the matter be listed for admission hearing after 6. Read the judgment properly. That judgment says all writ petitions were filed before the judgment is delivered, they are only entitled to consideration.
Lordship, there is a observation in the says judgment also, the cases which has been pending prior to 2017, that was also considered by the judge.
But there was an observation that this will not be treated as precedent. That also you have read.
That is there, Lordship.
So come prepared.
I
Come
am
prepared.
just praying for.
Yes, yes, come prepared. Yes.
May it please your lordship. Lord, at this stage, my lord, I only pray for issuance of notice because of the fact that the petitioner before your lordship, my lord, there was an advertisement, pursuant to advertisement, he appeared, my lord. And on the day of interview, my lord, he has come to know that the selection is going to be made on the basis of the mark obtained in the higher secondary. And if that is so, my lord, what is the point of holding the interview, my lord?
We'll just issue notice at this stage.
And there is no such cause of action also, Lordship, regarding this. They are just
So he's saying there is a-
anticipating that someone will be considered, Lordship. There is nothing on such on record, Lordship has been considered.
And you obtain instruction. Heard Mr. M.S. Chaudhary, Learned Senior Counsel appearing for the writ petitioner. Peruse the statements made in the writ petition. This petition has been instituted apprehending irregularities in the process of selection of candidates for appointment as Anganwadi workers stroke helpers in the Anganwadi centers, more particularly number 10 Bangbhag Solmare Anganwadi Center, coming within the jurisdiction of CDPO, ICDS project Koithalkuchi, Nalbari, by alleging that the respondents are seeking to violate the terms and conditions laid down in the advertisement notice. Considering the nature of allegation made in the writ petition, 2 weeks' time is granted to Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate Assam, to obtain preliminary instruction responding to the allegations made in the writ petition. 2 extra copies of writ petition be furnished to her. Let the matter be listed for motion again after 2 weeks.
Did you oblige, Lord?
Lord, 9, my lord, regarding the appointment of Gaon, my lord. The private respondent was appointed as Gaon, my lord, and thereafter, my lord, we have challenged the same by your filing a schedule appeal, my lord. And appeal was subsequently dismissed, and we have challenged the same, my lord.
Where is the order?
On 2 grounds, my lord.
Where is the order passed by the appellate authority?
My lord, page 91.
91.
No, sorry, sorry.
No,
41, my lord.
41.
Page 41.
Page 41. Page 41 is the, my lord, type copy, and 48 is the photocopy. Primarily on, my lord, 2 grounds. The first is, my lord, the petitioner before your honor is the son of a late Gaon, my lord. And his father is a government Gaon, and he was bedridden. He continued the same, and thereafter he expired.
So what is wrong with this order?
My lord,
What is wrong with this order?
my lord, this matter, 2 things were not considered. Firstly, my lord, so far the son of the Gaon is concerned, my lord, I am having the preference, my lord, and that is not considered. And secondly, my lord,
No, but on that preference, somebody's appointment cannot be disturbed. Preference is not a right.
that, my lord, right. If the other things are apart, my lord.
Yes.
And my lord, in the select list, my lord will find, my lord, that only 3 marks difference is there. And earlier, my lord, several litigations were winning in this particular, my lord, High Court. My lord, earlier, my lord, the interview was over, and thereafter, no result was given for long 1 year. And that the private respondent, he came, and in that petition, he said that I am serial number 1.
Mr. Chaudhary, I am asking you, what is wrong with this order? You said 2 grounds. 1 ground goes. What is the other ground?
Second ground, my lord, I am qualified, more qualified than him, my lord.
So how does it make a difference?
And he is from the outsider. I am insider. I am the son of the son.
Outsider means?
It was not considered. I am more qualified. It was not considered. And he was considered just because, my lord, earlier he filed a petition, my lord, where he himself has mentioned that my serial number at serial number 1. He challenged the same. And then, my lord, when the
At best, the notice can be issued, nothing more. Yes.
And there
I'm
is
issuing notice.
alternative media is also there, Lordship.
Huh?
Against the order of that appeal, there is a provision of review before the government. Lordship.
that's it, separate,
That-
my lord.
But Mr. M.H. Chaudhary, Learned Senior Counsel, listed by Mr.
R. Borwan.
R. Burwal, and counsel for the writ petitioner. There is the statements made in the writ petition. assailing the speaking order dated 11/6/2025 passed by the appellate authority, rejecting the appeal preferred by the petitioner under the provisions of clause 162 bracket C bracket close of the executive instructions framed under the Assam Land and Revenue Regulations, 1886, assailing the selection and appointment of the private respondent as Gaon Pradhan of Baj Batamari dash Dharmuk Kisamat, lot number 8 under Moja Jarawari, Kamrup district. Jarawari in the district of Nagaon, the present writ petition has been filed. According to Mr. Chaudhary, learned senior counsel for the petitioner, the issues raised in the appeal have not been considered by the authorities considered by the appellate authority in the correct perspective. Full stop. Mr. S. Datta, learned standing counsel, Revenue Department, Government of Assam, has prayed for some time to seek instruction. NOM 6 weeks. Since Mr. Datta has accepted notice for respond numbers
1 and 6.
1 and 6, and Mr. D. Bora, learned GA Assam, for respond numbers 2, 3 and 4. Service of notice upon the respond numbers 1 to 4 and 6 are deemed to be complete in this case, is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respond number 5 by registered post with AD.
And then
My lord, this case relates to the compassionate appointment. We have challenged the notification also, my lord. In the case, my lord, DLC has recommended my name, my lord, SLC, and the wrong interpretation, my lord, saying that I do not have the qualification.
Notice by Mr. J. Borwell and counsel for the petitioner, peruse the amendments made in the writ petition. The matter pertains to prayer of the petitioner for appointment on compassionate ground. The writ petitioner has also put under challenge the notification dated 18/9/2024 issued by the Government of Assam Personnel Department, thus abolishing the scheme for appointment on compassionate ground itself. Full stop. Mr. Dhar, R. Dhar, learned additional senior government advocate Assam, prays for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Dhar has appeared and accepted notice for all the respondents. No.
My lord, I am appearing for 1, 2 and 5.
Respond numbers 1, 2 and 5. And
rest, my lord, I'll supply to the standing counsel.
And Mr. R.R. Gogoi, learned standing counsel, PHE department, for respond numbers 3, 4 and 6. Service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite numbers will furnished to the learned department counsel so as to enable them to obtain instruction. Is this case again by reflecting the name of learned departmental counsel in the cause list?
11. Lordship. In this case, one of the petitioner of lordship was initially appointed as casual worker.
Yes.
The petitioner of lordship was initially appointed as casual.
Why don't you use the mic? It's not properly placed, the mic.
Well, in this case, the petitioner of lordship was initially appointed as casual worker. He participated in the selection process in the year 2001, and Malad, she got selected. She was placed at serial number 4. Thus, you will find the select list at page 22, my lord.
Page 22.
My lord. My name is placed at, my lord, serial number 4, and one Bhuvneshwari Sharma, she was placed at serial number 5. The person placed at serial number 5 was regularized by order at page 26, my lord.
Yes.
page 26, my lord.
So you are seeking release of arrears salary, then regularization, lot
My lord,
of.
my lord, my service has been regularized, but my lord, with prospective effect from 2024. My lord, I am seeking a direction, my lord, for giving it retrospective effect, my lord, as it has been done in the cases of other selected persons, my lord.
Yes.
Lordship may issue notice at this stage.
Take down. Heard Mr. I.H. Sekhar and counsel for the petitioner peruse the averments made in the writ petition. The case of the petitioner in a nutshell is that she was originally appointed as an LDA cum typist in the establishment of Child Development Project Officer, Nazira, on fixed consolidated pay of rupees 900 per month. Thereafter, her service was regularized in the said post. The grievance of the petitioner is that her services ought to have been regularized with retrospective effect from the date of initial appointment.
My lord.
That apart,
No, my lord, from the date of her selection, my lord.
from the date of her selection for the post of LDA cum typist. That apart, the petitioner has also sought a direction upon the respondents to release her arrear salary. Full stop. Mr. D. Boral and G. Assam praised for some time to obtain instruction. NOM 4 weeks since Mr. Bora has appeared and accepted notice for respond numbers. All the respondents.
1 to 5.
1 to 5. And Mr. P. Nayak, Lanet, additional AG and Standing Council Finance, additional AG Finance, Loft of Assam, for respond number 6. Service of notice is deemed to be complete in this case, extra copies of the writ petition.
Also, we take this matter along with WPC 7238/2022, my lord.
On the
Similar-
prayer of Mr. I.H. Sekhar and counsel for the petitioner, let this writ petition be listed along with WPC number.
7238 of 2022.
लिख दो number listed again along with.
Oblige, my lord.
Yes.
This is regarding challenging my transfers from one department to another department. From non-technical post to a technical post, which I, as part the provision of the certified standing order company is prohibited, and they have admitted it, So I filed a representation, when the representation pending, they did not act on my representation. I approached before this honorable court in the first round of litigation. And that order, my lord, will find it page 72, part short, my lord.
Page 72.
Page 72. Start from page 7.
Yes.
Then, my lord, the status was directed to be maintained in disposal of this my representation. Then, my lord, impugn order, lordship will find it page 75. Against which I have again approached before this, your lordship. In my lord, will your lordship come to page 76, my lord. Second paragraph. So, my lord, they have admitted that it is functionally distinct from the post I am, because it is a highly technical post and I was an administrative post, my lord, which is prohibited under clause 11 of the certified standing order, which is binding on the, my lord, the corporation employer, my lord. And I have just 1 year and few months to go before my retirement, your lordship.
No, I've understood, but are these matters for the court to look into? Has your pay and allowance, salary structure, anything been?
My lord, certified clause 11 says despite of my lord pay and everything remains the same, but if the it's functionally my lord the different, you cannot transfer him. My lord, you may look into pays, my lord. I'm just taking your lordship to certify standing on there, my lord. It is paid,
No,
my
Mr.
lord,
Ghosh,
645.
you are not getting into one issue.
My lord.
They may violate their own regulation.
Yes, my lord.
That's not a subject matter of court.
Yes.
You have to show how it has prejudiced your right. That is the question. It is their internal domestic rules. They
No,
may
my,
violate.
it is statutory rule. It is
All
statutory.
right, but
certified.
how does it prejudice your interest? Has your condition of service been changed?
No, my lord. If your lordship look into 11, my lord, clause 11. It
No,
says-
if you say no, then there is no case.
My lord, it
Unless there is a violation of
It is
condition.
prejudiced because, my lord, they cannot, lordship will say, workmen may be transferred due to exigency of work from one department so and so to another, provided that pay grade, continuity and the condition of the service employment are not adversely affected by such, my lord, by such transfer, and provided also that an employee is transferred from one duty to another job, the job should be of similar nature. And as such, he is capable of doing. So they have also this functionally different, my lord. So they cannot violate.
You are appearing.
Lordship, just since
Yes,
nobody
central
was
government, my lord. He is appearing on
since DSG's name has been shown, that's why I just
but
walked
it
in.
is belongs to oil, my lord, because they are not standing.
Why don't
counsel.
you just get
standing
the
counsel.
preliminary instruction and tell us? We'll have it next week, Monday, for
Oil?
motion.
No, no, oil. Oil, my lord.
Oil India Limited is the, Mr. Nayak is there, Lordship.
Who's there?
Mr. Nayak. P. Nayak.
There is a standing council. I think.
He normally appears, Mr.
No,
Nayak.
they have to issue notice, then they appear, my lord. Motion may fix next week, my lord, and in the meantime, the status quo may be made.
No, let him obtain instruction. Mr. Nayak is, can you please send a message? Just wait for a minute. Let him come. Yes.
So motion may fix up next week also obtain
You don't have
instruction.
any case. Take it from me. But we'll give you some breathing space, which is what you want. Huh? Yeah. Mr. Nayak, are you normally appearing in these matters? This this is IOCL.
In some matters, I appear, Lord.
Achha, then can you just take some instruction in this
Yes.
case? We'll have it next week, say Tuesday.
Okay.
Next Tuesday
Well,
for motion.
yes.
Heard Mr. B.J. Ghosh, learned counsel for the petitioner, appears the statements made in the writ petition. The petitioner is primarily aggrieved by the order dated 13/6/2025, passed by the Deputy General Manager bracket HR of the IOCL, rejecting the plea raised by the petitioner. According to Mr. Ghosh, the stand of the authority is contrary to the statutory prescription applicable to the corporation. First up, on the request of this court, Mr. P. Nayak, Linus Council, has authorities preliminary instruction from the ISLA authority responding to the grievance raised in the writ petition. This case again on Tuesday, the 22 of 7/2025 for motion by reflecting the name of Mr. P. Nayak, Land Council in the cause list. 2 extra copies of the writ petition be furnished to Mr. Nayak. Let us see if you can make out a case of violation of conditions of service.
Yes.
We'll interfere. Otherwise, no.
Petition. This petitioner before Lordship was a part-time sweeper cleaner. They have been working over their respective places more than 10 years, my lord. Their only grievances is that their service may be full-time sweeper, and their service, their stipulated the payment should be enhanced. That is the only ground, my lord. They have been working and getting 2,250 per month.
No, but why that service should not be continued? What is the reason why you have?
They are part-time service.
Yes.
Yes,
What is your
more than 10 years they are working.
right? So what is the grievance?
Their given is to my lord, they should be make the full-time sweeper, my lord. And their service may be enhanced, my lord. It is only.
I heard Mr. B.P. Sinha, Learned Counsel for the petitioner. The writ petitioners herein are serving as part-time sweepers under the respondent authorities for more than 10 years. Their prayer is for issuance of a direction for regularization of their services in the post of sweeper. Mr. Ardhar Lanet, Senior,
For all.
Senior Government Advocate Assam, appearing for all the respondents, please for some time to obtain instruction, NOM 6 weeks, extra copies, etc.
Okay.
May I please elaborate this matter regarding compassionate appointment? We are challenging the office memorandum dated 18/9/2024, Lordship. Lordship, as per the order dated 24/3/2023, the petition.
We'll issue notice, that's all. Heard Ms. A. Begum, Learned Counsel.
May I submit something, Lordship? Kindly have a look, page number 34, Lordship.
Page number 34.
Lordship.
Yes.
Petitioner name is Jakaria Amanullah Chaudhary and 26 number Ibadur Rahman Lashkar. Ibadur Rahman Lashkar filed petition before this honorable court, and this honorable court was disposed of the matter.
In the motion stage,
Lordship.
you are agreeable to such an order? Yes, heard Ms. A. Begum, Learned Counsel for the petitioner. Peruse the statements made in the writ petition. The matter pertains to prayer for appointment on compassionate ground. The petitioner has also assailed the notification dated 18/9/2024 issued by the Government of Assam, Personnel Department, abolishing the scheme for appointment on compassionate ground. Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate Assam, prays for some time to obtain instruction. Issue notice returnable in 6 weeks. Since Ms. Bhattacharjee has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition, requisited number.
15.
May I please, Lordship? I am on behalf of B. Fukon. The conducting council has informed me that he is out of station.
Passed over for a week on the request of petitioner's counsel. Passed over for a week.
50. Lord, this petition has been filed, assailing, my lord, the communication at page 39. In fact, my lord, this is the third round of litigation. Initially, the petitioner filed a writ petition praying for regularization of her services. This honorable court, my lord, on 27/3/2024, had directed that the petitioner be paid the minimum of the pay scale, which is applicable to her. The operative portion, my lord, is at page 30. Thereafter, my lord, nothing had happened. The petitioner was constrained to file a contempt petition. No, sir.
So you are agreed by this order?
I'm agreed by the order of the release of the amount of rupees 2,40,000, because I have also appended certain educated assumption of the payment which is applicable to me, which ought to have been applicable to me for the past 20 years of services rendered. It comes to around 28 lakhs, something, my lord. But that is a tentative figure that I have appended. And I was paid, my lord, at page 40 is the fee statement which was released to me. 2,40,000. In fact, there was a contempt petition also which was pending and which was closed, my lord, because there was a purported compliance with the order in judgment, my lord. However, my lord, that the order of disposal.
This amount has been issued to you in terms of which order?
In terms of, my lord, the order at page 18, the operative portion is at page 30, my lord. 27/3/2024. Passed in WPC number 479 of 2013.
So notice has to go.
Notices has to.
Heard Mr. M. Sharma, Learned Counsel for the writ petitioner, peruse the statements made in the writ petition, being agreed by the order dated 10/2/2025, issued by the Deputy Director Admin of Northeastern Regional Institute of Water and Land Management, releasing a sum of rupees 2,40,151 as arrear dues payable to the petitioner in purported compliance of the judgment and orders dated 27/3/2024 and 28/6/2024 passed by this court. The instant writ petition has been filed. Mr. Sharma submits that his client is totally dissatisfied with the amount released to her, as the petitioner claims to be entitled to a sum of rupees 28 lakhs as arrear dues.
In that range.
Mr. B. Chakraborty, learned CGC, appearing for the respondents, has prayed for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Chakraborty has appeared and accepted notice for all the respondents, no formal notice, extra copies, etc.
I'm good.
17.
May it please your lordship. Lordship, the petitioner was recruited as a sepoy in Assam Tea Plantation Security Force in 1993. But however, in the later period,
Yes.
The petitioner, along with other similar situated sepoys, approached this honorable court and lordship, in this civil rule number 1584 of 1997, decided on April 22nd, 2002. They were directed to be regularized. And the order says that to give a permanent status along with consequential time scale of pay to such members of the force who may be in service as on date. And as on date, the petitioner was in service. However, lordship, one aspect I have to bring to your lordship attention is that before this, on 19/3/2021, when I approached Honorable High Court, my writ petition was disposed of with a direction to respondent number 2 to consider my representation and pass appropriate orders within a period of 2 months. But they refused to act on this order. Therefore, on the same year, that is 2021, I had to file a new writ petition, and it was disposed of on 17/12/21. Because lordship, what happened here, instead of filing an affidavit, on 17/12/21, they served a copy of an order which I have challenged in this writ petition, the discharge order. The discharge order.
Where is the discharge order?
Lordship.
It's taking a long time.
Lordship, it's page 44, annexure I.
We'll issue notice at this stage only. You are Mr.
S. Saman.
S. Saman. Heard Mr. S. Saman, learned counsel for the Saman or Zaman?
Zaman, Z-A-M-A-N.
Z-A-M-N. Learned counsel for the petitioner. Peruse the averments made in the writ petition. The petitioner, while serving as a sepoy under the AISF, Battalion 1, was discharged from service on 1/12/1997 on account of unauthorized absence from duty. Thereafter, his application for taking him back in service was also rejected by order dated 20/3/2021. Being inter alia aggrieved by the order dated 20/3/2021, the petitioner has approached this court by filing the instant writ petition. Mr. C.K.S. Borwal and You are appearing for
All the responses.
Learned G. Assam. Appearing for the respondents has prayed for some time to obtain instruction. Only NOM 6 weeks. Since Mr. CKS Borwa has accepted notice for all the respondents, no formal notice, extra copies.
Deeply.
Possible.
Can you allow me to withdraw this petition with the liberty to file it fresh? There's
Some mistake. All right. Mr. R. Medhi and
Bora.
R. Bora, sorry. Why have you written Medhi here?
this petition
Somebody
is filed
else.
by Armedi. My name is in the Wakalat number. It is not.
Your name is not here.
No, it is in the Wakalat number, but not shown in the cost.
Mr. R. Bora, Learned Counsel for the petitioner submits that there is some mistake in the writ petition and therefore he be granted leave to withdraw the same with liberty to file afresh. The prayer is not opposed by Mr. D. Nath, Learned Senior Government Advocate Assam, appearing for the state.
This is APGCL.
Appearing for the APDCL.
APGCL.
APGCL. In view of the above, this writ petition stands disposed of on withdrawal with liberty is paid for.
Okay.
Lordship. Lordship, here, my lord, I have instruction to withdraw. I have instruction to withdraw, my lord, with liberty to file it if necessary.
Under instructions from his client, Mr. Amar Khandekar seeks leave of this court to withdraw the writ petition with liberty to file afresh as and when a proper cause of action arises. Mr. T.J. Mohanto, Learned Senior Counsel, assisted by Ms. P. Sharma, is present on behalf of respondent numbers 2 and 3. Stop. Mr. D.P. Bora, Learned Standing Counsel,
Health and Family Welfare.
Health and Family Welfare Department, Assam, has appeared for respondent numbers.
All other respondents, my lord.
For the remaining
I am for 5, 6, 7, 8, 9, my lord.
5,
And
6, 7, 8, 9. And Mr. CKS Purwa, Learned G. Assam for respondent number 1 and 4. On the request of the Learned Counsel for the petitioner, this writ petition stands disposed of on withdrawal with liberty is paid.
And this will be.
I should Lordship, in view of the Lordship, page 27, here is a question of pensionary benefit to the employees, those who are working more than 20 years. At leveling the tag of the worker, they are depriving in view of the office memorandum, page 39, as well as office memorandum, page 41. In these two cases, my lord, there are more than 20 years of service since 1994.
This is against what? Karbi Anglong Autonomous Council.
Autonomous Council. Public Health Engineering Department, as well as page 43 notification 2013. That also provided.
Yes, Mr. Nayak.
Yes, we notice.
Right, heard Mr. B. Sharma, Learned Counsel for the writ petitioners. There was the amendments made in the writ petition. The petitioners were allegedly appointed as temporarily appointed as workers Khalesis. When you were appointed? When?
1994.
In the year 1994. Since then, they are continuing to discharge their service. Stop. According to the petitioners, due to long and continuous discharge of service, they ought to be treated as regular employees for all practical purposes. And therefore, the departmental authorities are bound to extend pensionary benefits and other retirement dues to the petitioners in accordance with law. Mr. P. Nayak, Learned Standing Counsel, Learned Additional AG Finance, Assam, and Ms. S. Kempai, Learned Standing Counsel, Karbi Anglong Autonomous Council have both prayed for some time to obtain instruction in the matter. NOM 6 weeks. Who's for whom? Who's for number 1? You don't. Mr. Sharma, huh?
Public Engineering Department.
Public Health Engineering.
2. 1.
So what to do? Sure. Mr. R. Bora for response number 2. Ms. S. Comprise for response numbers 3, 5. Mr. P. Nayak for response number 4. Mr. D. Bora, learned G. Assam for response numbers 1 and 7, and Mr. S. K. Medhi, learned Standing Counsel for the Office of Accountant General, Assam, for response number 6. Service of notice deemed to be complete in this case. Extra copy of the writ petition requisite in numbers be furnished to the
21 also same man. Cardinal.
same.
Same party.
I am for Economic 6 fellow, Accountant General in Assam.
Acha. Same thing, only response number 6, Mr. C.
Shivarua for
List along with item 20.
6.
20.
That's one of 6. I'll do that.
Rest will be also.
Extra copy also.
For April to item 22.
In this case, I am appearing for the petitioner, but see the petitioner retired in 2019. He is entitled to about 7 lakhs as a leave-in case file. In spite of their admission, but till date payment is not due.
No, but this case has been identified to be referred to mediation. Is your client?
The issue here, Lordship, they have admitted in their affidavit. On last occasion, they submitted a proposal.
Only order I'll pass is either refer to mediation or don't refer to mediation.
Lordship may,
Here, the writ petition will not be disposed of today.
Lordship may hear the matter on some other day.
All right. Add Mr. S. C. Kyle and counsel for the petitioner. This matter was identified for being referred for mediation under the special mediation drive for the nation undertaken by the judiciary. However, today when the case is called up, Mr. Kyle submits that his client is not willing to subject himself to mediation. In view of the above, let this matter be listed in the appropriate column for disposal in the month of August 2025.
Item 23.
The petitioner husband was working as a grade 2 employee, my lord, and the ASCB department, my lord. And he died in the year 1990, my lord. The wife, widow, my lord, lady getting only 1,000 rupees per month.
Mediation?
No, my lord, it is not possible because, my lord, as she is getting as per her entitlement as per the act, my lord. If lordship sees page 20 of.
All right, heard Mr. JNU Lashkar, learned counsel for the petitioner. JUNM Lashkar, learned counsel for the petitioner. Also heard Mr. S.K. Chakravarti, learned counsel appearing for the respondent number 7. After hearing the submissions made at the bar, this court is of the opinion that mediation is not possible in this case. As such, let the matter be listed in the appropriate column in the month of August 2025.
24.
Lordship, matter pertains to non-payment of provident fund, gratuity and other service
We
benefits.
refer it to mediation. Miss, your name please?
F inter-
Miss F. Intel, learned counsel, has appeared for the petitioner. Mr. C. Barua, learned counsel, is present on behalf of the
Response number 7, Accountant General.
respondent number 7. Mr. P. And who else is there? Mr. P. Nair, learned addition AG Assam, has appeared for respondent numbers 2, 3, 4 and 6. Mr. D. Bora, learned G. Assam, for respondent numbers 1 and 5. After hearing the submissions of learned counsel for the parties, this court is of the opinion that there is scope of resolving the issue by means of mediation. As such, with the consent of learned counsel for both the sides, this matter is being referred to the Guwahati High Court Mediation Center for exploring the possibilities of settlement of the dispute
Oh.
by means of mediation. Let the report of the mediator be placed before the court within 60 days from the date of receipt of record. List accordingly.
Lordship, can it be taken after some time?
After?
After some time.
26.
Yes, my lord, actually, I'm claiming from all the pension benefit under Assam Service Pension rules of this. My lord, in this case, my lord, this honorable court in the division bench is held in open case, my lord, that. they are
Have
not-
you seen the headline?
I
Have you
have
seen the-
seen, my.
Only order will be passed is mediation, no mediation.
My lord, in the matter. this
Nothing
matter is
else.
Pending before the apex court, I am told, entire matter, my lord. So let-
You are not
let it be
agreeable to
after after 6 weeks or so, my lord, before, without, not refer to the mediation, my lord, let the matter be decided. We are waiting for the Supreme Court.
Then I'll record that your client is not willing to go for mediation.
Because, yes, my lord, because, let the matter.
Mr. Vijay Ghosh, learned counsel for the petitioner submits that his client is not open to go for mediation. And therefore, this matter be decided on merits by this court. Mr. P. Nayak, learned additional AG Assam, and Mr. C. Borua, learned standing counsel for the respondent number 3 are present. In view of the stand taken by the petitioner's counsel, registered to list this case again in usual course for adjudication by this court.
7.
None appears for the petitioner when the matter is called up. List again after 2 weeks.
28.
There is no scope for mediation, Lordship. And last occasion, they had taken time for filing affidavit in opposition. Lordship.
I'll file affidavit in opposition.
Ms. Kanungo, learned counsel for the petitioner submits that as Kanungo, learned counsel for the petitioner submits that there is no scope of mediation in this case, and therefore the matter be decided on merits. Mr. P.J. Sekyan and P.J. Fukan, learned counsel appearing for the respondent number
2, 3, and 4.
2, 3,
Standing
and
counsel
4.
Guwahati.
That is Mr. P.J. Fukan, learned standing counsel
Guwahati.
Guwahati University appearing for the respondent numbers 2, 3, and 4. Prays for further 3 weeks time to file affidavit. Prayer allowed. List the matter accordingly.
Most of.
29.
My lord, as per last order, my lord, NIG government has to file affidavit in opposition.
No, mediation possible or not?
Yes,
Possible.
yes.
What is the matter here?
Regarding my lord, pension, my lord. Non-payment of pension.
You take doubt. The controversy involved in this writ petition pertains to prayer for payment of pension. Mr. D. Gogoi, learned counsel for the petitioner, and as well as Mr. N. Upadhyay, learned standing counsel irrigation department, appearing for respondent numbers 1, 2, and 3. And Mr. R.K. Talukdar, learned counsel for the Mr. P. Nayak, learned counsel for the respondent number 4, and Mr. R.K. Talukdar, learned counsel for respondent number 5 and 6, have all agreed that there is scope of settlement of the dispute involved in this writ petition through the process of mediation. In view of the above and with the consent of learned counsel for all the parties, this matter is being hereby referred to the Guwahati High Court Mediation Center. The report of the mediator be placed before the court within 60 days from the date of receipt of record of this case. Let the matter be listed accordingly.
Item 30.
This matter, and we file reply, my lord, because the issue has to be decided, my lord.
Will refer it to mediation. Agreeable?
No, my lord.
Mr. H. Gupta, learned counsel for the petitioner, submits that his client is not willing to go for mediation so as to arrive at an amicable settlement of the dispute. As such, the matter be decided on merits. Mr. C.K.S. Barua, learned G. Assam, Has appeared for respond number. Mr. C. Borwal, learned anybody else? Respond number 7.
Say, finance and AG is also, finance is also there, sir.
Mr. P.
It's
Nayak,
number
learned additional AG. Finance for respond number 3 and
I'm appear for respond number 1, 2,
list accordingly. Yes. You have for respond numbers?
1, 2, 4, 5, 6, and 8.
31.
31, who is appearing? None appears for the petitioner when the matter is called for. Ms. K. Fukan, learned CBC is present on behalf of the respondent. Since the petitioner's counsel is absent to the list again after 2 weeks.
Oblige.
Time being item 25.
Directly to produce the certificate that it is a
Mediation or no mediation? That's the only order that will be passed to them.
congenital, the involvement.
No mediation.
Yes.
Okay. Mr. S.C. Biswas, learned counsel for the
Mediation is possible. I have.
Lordship, in this case, law is involved, Lordship. Because, Lordship, we have denied his pension, page 39 may be Peru's, Lordship. He has to silence this letter, Lordship, because by the.
No, you
by-
quoted it. He is willing to go for mediation.
Lordship,
You are appearing for whom?
Accountant General, Lordship.
And
We have
what about
rejected his case, my lord.
Mr. S.C. Biswas, learned counsel for the writ petitioner submits that his client is willing to go for mediation so as to arrive at an amicable settlement of the dispute and therefore would not have any objection if the matter is referred to the Guwahati High Court Mediation Center. Mr. R. Dhar, learned additional senior government advocate Assam, appearing for respond numbers.
PWD.
Standing counsel PWD appearing for respond numbers 1 to 11, is it?
Yes, my lord. 1, 2, 3, my lord. And
1, 2, 3,
and 4 or 5 appear.
1 to 4, and Mr. R.K. Talukdar,
Hi,
learned
my lord.
counsel for the respond number 5 are also agreeable to such an order. In view of the above, registry to refer this matter to the Guwahati High Court Mediation Center so as to explore the possibility of a mediated settlement of the dispute involved in this case. The report of the mediator be placed on record within 60 days from the date of receipt of the records of this case. Let the matter be listed accordingly.
Item 32.
In this case, I need 2 weeks time to file affidavit, lordship. The last date, I have only reconstructed the file on 11/6, lordship.
There is an interim order operating.
Interim order that the impugned gradation list may not be given effect
Yes,
to.
we will not.
10 years junior has been placed above me, lordship. Second round of litigation, it's been 1 year, 6 months. They have not filed any reply, lordship, till now.
Last chance, 3 weeks.
Yes, lordship. Actually, I am appearing on only from 11/6, lordship.
Only?
From 11/6, 11th. Okay, last chance.
How did you file your affidavit?
That's
Because here once
There is an order also that endeavor will be made to this.
heard Dr. G.J. Sharma and counsel appearing for the writ petition, also heard Mr. P. Sharma and standing counsel AFDC appearing for the official
You
response.
see, it should be fishery, lordship. It's wrongly written as ABC, lord.
Learned standing counsel for the fishery department appearing on behalf of the official respondents who seeks further 3 weeks time to file counter affidavit with an assurance to the court that no further adjournment will be sought on that doubt. In view of the above, 3 weeks time is granted to the respondents to file counter affidavit. Registry to list this matter again after 4 weeks as a fixed item. Interim order passed earlier to complete.
May I pray, lordship? In the cause list, instead of ABC, fishery may be reflected.
This matter will be listed again by showing the name of Mr. P. Sharma as standing counsel for the fishery department.
Highly obliged. Highly obliged.